Well, good morning, everyone. Good to see you all. Appreciate you being here. We are very excited here at the Tucson Metro Chamber. By the way, I'm Michael Guyman. I am the interim president and CEO for the Tucson Metro Chamber, and we are very happy to present this information to you. Information about the Tucson Minimum Wage Act that was passed by the voters earlier this month. There's a lot to unpack with this. So I'm not going to do too much of an intro because we really want to get to the meat of this, but I do appreciate everyone being here to be a part of this conversation and learn more about what this entails for the businesses here in Tucson. So with us today are Tim Medcoff, as you see here on the screen, with Farhang and Medcoff, and there's his email address. Also with us is,
I think you need to click on the continue.
There we go.
There we go.
Also with us is Richard Bratt, CPA with BeachFleischman. So I want to thank you both very much for being here to share this important information with us. And we will go ahead and get started with you, Tim.
Perfect. Thank you, Michael. Thank you all. Most of you, if not all of you, are the leaders of your organizations. You head up your HR group, your CEOs, COOs, etc., as well as employees of your respective companies. So this new law, new act, and the implementation in two different capacities. Just as a friendly reminder, I know we've all been doing Zoom for almost 2 years now. If you're not speaking, please go ahead and mute your lines. Both Richard and I want this to be helpful for you. So if you have specific questions that are weighing on you, by all means, type them into the chat or raise your hand. Mike will interrupt us so that we can get your questions answered. Odds are most of your questions will be answered in the materials that we have prepared, and we will email you those materials after the presentation. But to the extent that you have something that is keeping you up at night as it relates to the implementation of this new Minimum Wage Act and its impact on your business, by all means, put it in the chat, and then we will stop the presentation, because it's a lot more fun for Richard and I if we get to answer questions as opposed to just go through a lecture on this topic. So as the slide you have in front of you is just kind of giving you a recap of what we're going to cover related to the new Prop 206 and the Minimum Wage Act. Like a lot of voter initiatives, this act has a lot to unpack in it. It's not just increasing minimum wage. If it was just increasing minimum wage, this would be a very simple, short presentation. We tell you when the deadlines are for the minimum wage increases and what your potential exposure is if you violate it. Unfortunately, this act has a ton of other sticks in it that the unwary employer could inadvertently step into a pitfall and create legal liability for themselves. So it's not in the slide presentation, but if you're an employer that has any number of employees, you definitely want to call your insurance provider and talk to them about getting employment practices liability insurance. EPLI is the acronym. And you also want to ask for a rider, RIDER, for wage and hour claims. And that's the key issue, because the employment practices liability insurance is going to cover you for wrongful termination, discrimination, retaliation claims. But the rider for wage and hours would cover claims that you're not paying appropriate minimum wages or overtime to your employees. And if you don't have the rider, then your EPLI policy likely will not cover wage and hour claims. There's usually an exclusion for wage and hour claims. That's why you need to purchase the rider on top of it. Depending on your size and of employees and what industry you're in, a lot of those policies are not that expensive when you add them on to your commercial general liability, your directors and officers liability, and any other insurance policies. So reach out to your insurance broker. If you learn nothing else from this presentation, I hope you just remember that. That's why I started with that. So we'll we'll explore the impact of this act as it gets implemented. With that, we'll go to the next slide, Michael. So just general background. This was a voter initiative, and it was passed on basically a 60-30 split. The difference was just people that didn't vote. The other things that happened in the last election, we won't talk about them, but they're on this slide in case you're curious about what happened with the other ballot initiative. Go ahead, Michael. So we're going to focus obviously on Prop 206. Go ahead. So just summary, it was a voter initiative, ballot initiative called the Tucson Minimum Wage Act. It increases minimum wage from currently $12.15 an hour up to $15 an hour by January 1st, 2025. And it applies to all individuals that work at least 5 hours per week within the boundaries of the city, with a few exceptions. Now, so if you're an employer inside the city limits, then this act applies to you. If you're an employer whose place of business is outside the city limits, the act could still apply to you if you have employees that work in the city limits. So the example I've been using is, let's say you're a landscape company and your business is located outside the city limits. If your landscape employees work more than 5 hours within the city limits in any given week, you've got to track the hours they work in the city limits, and you've got to pay them at minimum wage for the city of Tucson. So right now, if you're paying your new hire $12.50 an hour to do work throughout the county and the city, effective April 1st of 2022, you're going to have to pay them at least $13 an hour for the hours that they work within the city limits. And I do have a slide on this, and we'll talk about it a little bit more in depth. And I'm sure Richard's going to talk to you from an accounting standpoint about the importance of tracking hours worked by your individual employees wherever they're doing that work, which creates a huge administrative hassle and burden for small employers. Go ahead, next slide. So just a general timeline, and the reason why I'm raising this is because this is a voter initiative. So if this was a legislative change, it would be much different. And we're going to talk a little bit about the difference between a voter ballot initiative versus a legislative enacted statute. But because this is a voter ballot initiative, it makes it really hard for the legislature to amend or change the voter initiative. They basically got to put it back on the ballot for a vote. So that means that the initiative as enacted is what's going to be enforced. And a lot of the decisions on that are going to be determined by the courts. So, you know, I joke tongue in cheek that this is really a boondoggle for attorneys, unfortunately. So people like me are going to be really busy with questions and lawsuits and defending the lawsuits. And the employers are going to be left shaking their heads or confused, because this, again, is not just a minimum wage increase law. So that just gives you a little background on how we got to where we are today. Go ahead. Next slide is just kind of listing all of the individuals that supported it. And obviously, I'm tainted as a labor employment attorney who does mostly employment defense work for employers. But obviously, some of the supporters are nonprofits that I support with my own time and money. There also were a number of individual employers that supported this. And Billy Perd, who I have a lot of respect for, was one of the co-authors of it. And I know Amber Smith had a debate with Billy on this with the Daily Star, just kind of going through the pros and cons. But as we all suspect, a lot of people just voted for this in favor of it because, hey, I'm in favor of people getting paid more minimum wage without knowing the other ramifications of the law. Next slide. So these were the ones that were primarily against it. The Tucson Metro Chamber, who I'm the immediate past board chair of, amongst others, were against it for a variety of reasons. And most of those reasons was not the minimum wage amount itself. It was because of all the other stuff that we're going to talk about today. Go ahead, next slide. So as I alluded to, because this was a voter initiative with 60% approval rating, the legislature can't unwind it without approval of the Tucson voters. So even though there's problems with this law, and the example I use is it carves out babysitting. So if you have a babysitter who works at your home, they're exempt, and you're exempt. You're not an employer, but it doesn't. By including that definition, the argument could be made. Okay, well, if I have a landscaper that does work at my house, or a house sitter, or a pet sitter, or a house cleaner that comes to my house and they clean for more than 5 hours in any given week, and I pay them less than 13 bucks an hour and I live in the city limits, then you could arguably fall within the ambit of this law, even though you're not an employer, they're a worker for hire. Because of the definitions in this law, it covers workers for hire, which would typically be independent contractors. And typically you and I aren't tracking how many hours a house cleaner may be working at the house to clean our house, because we're not there. We're at the office. We give them a key to the house and they come and go whenever they get there, and then they finish when they finish. You know, that's going to be a problem potentially. And as the quote says, the mayor and council can't unwind it either unless they submit it up to a vote for the people. Next slide. So this slide sets forth the minimum wage increases. Now, what's of interest for those of us that, like Richard and I, that represent a lot of restaurant owner operators, they're already paying more than 13 bucks an hour. In fact, one of my good friends and clients is the McDonald's owner operator in town, and he's paying 14 or 15 bucks an hour, depending on the store and location, because he can't get good help for less than that. And then the other reality is, with inflation, under the state minimum wage law that went into effect back in 2017, that's going to bump to $12.80, irrespective of if Tucson had enacted this statute or this ballot initiative. So that delta obviously is only 20 cents, but that's going into effect immediately on January 1st of 2022. And then 4 months later, you as an employer got to give another 20-cent bump if you have minimum wage people working for you and you're in the city limits. Then a following year, it's going to bump to $13.50, the following year to $14.25, and then the following year to 15 bucks. And then after that, it's going to increase based on inflation, et cetera. So that's the reality. And if this was the only issue in the ballot initiative, we wouldn't be talking honestly today. So that's in effect, whether you're a small employer with one employee or you're a larger employer with 50 employees or 100 employees. You've got to meet these minimum wage requirements if you're within the city limit, or if you're outside the limit and you have people that work within the city. So if you're a construction company, a landscaper, et cetera, and your people work in the city limits, then these are the minimum requirements that you have to meet. Next slide. So what does this mean for you? Go ahead. So the act only allows an employee or somebody acting on them to collect back pay, liquidated damages, which is double damages, attorney's fees, and costs. So hypothetically, if you don't pay the appropriate minimum wage, or somebody makes a complaint, which they can do so confidentially, then that's the exposure for you. So obviously it means you need to be doing self audits and making sure you're paying your people appropriately. The problem with this law, amongst others, is if you're an employer and you're doing everything right, but somebody files a frivolous claim or a groundless one, you still got to defend that. If you don't have insurance, then you're having to pay out of pocket to a lawyer like me to defend it for you. Because if you're an entity, you can't defend yourself in court. You have to have an attorney do that. If you're a sole proprietorship, you could defend it yourself, but I don't recommend you do that, because then your personal assets are exposed. And even if you prevail on that groundless, frivolous claim, you don't recover anything under this act. Now, you may be able to recover under a different Arizona statute or rule, but at least under this act, you can't recover anything. So you prevail, you win, you prove it's totally groundless, had no merit. Sorry, you don't get to recover under this act. So a lot of times you as an employer are going to have to make a business decision. Where do you spend your money? Do I settle this stupid claim that I know is worthless because it's cheaper for me to settle it than to hire Tim Medcoff or another lawyer to defend it for me. And unfortunately, that's going to be a business decision that you're going to have to make. And that's what I tell clients all the time. It's not about me, it's about you. And the last time I checked, you're not making money when you're talking to your lawyer. You're typically making money when you're selling your services or your products. Next slide. Any person or entity may file a claim. As I mentioned, it's a confidential complaint. So your competitor, frankly, could file the complaint. Even again, if it's frivolous, has no grounds or merit, they can file it. You've got to defend it, and the city's got to investigate it. In fact, the law puts in it that they have 60 days to investigate. And just to give context to that, if there's a discrimination claim filed with the Arizona Civil Rights Division or the Equal Employment Opportunity Commission, the ACRD has a year to investigate it, and the EEOC has unlimited time to investigate it. But under this act, the city Department of Labor, which gets created by this act, has 60 days to investigate it. If not, a interested party or the individual could ask to file a lawsuit on behalf of the employee or employees that have allegedly paid minimum wage and file that lawsuit in city court. So again, a competitor could file a frivolous claim against you, and the city has to investigate it, or somebody could file a complaint on behalf of the individual or individuals. And again, there's no fee shift on it if you win that false claim or frivolous claim. Next slide. The other thing the act does is it expands the definition of aggrieved parties to include workers for hire, which are typically independent contractors. So the problem with that is Arizona state law allows you to hire and use independent contractors, which all of us tend to do on discrete issues. But this new act is counter to that, because it's expanding aggrieved parties to include workers for hire. So if they're not, quote unquote, getting paid minimum wage, then they could potentially file a claim against you. And you and I both know the whole purpose of hiring independent contractors, you can bargain for, hey, I want to do this project for X dollars. And you don't care how long it takes them to do. That's on them. They can make a profit or not make a profit. That's up to them. But they could, intentionally perhaps delay the amount of time it takes them to do the project and say, well, hey, you didn't pay me minimum wage. I'm entitled to minimum wage because I'm a worker for hire. And now we've got a conflict between state law and the city act. So what happens with that remains to be seen. But, clearly somebody's going to be that guinea pig, which is unfortunate. Next one. So with that, I'll turn it over to Richard and take a quick breather and let him talk about some slides.
Okay, well, good morning, everybody. I just want to talk about some accounting, tax-related types of things that would affect the business. Tim hit on a number of things that many employers are already paying $15 an hour. Part of that is due to the economy and the fact that a lot of people aren't going back to work. Like he said, the $15 an hour minimum wage is somewhat meaningless. It's the other things that come into effect that you have to comply with. So, there's a further definition of what a large employer is, and that's 26 or more employees. And there's some criteria on how you determine that. It's based upon, I think, the quarter of the prior year, if you had 26 or more, and it's not FTEs, it's just a pure number of employees. So one of the things that happen, a lot of people hire a lot more employees in December due to seasonality and the holidays. So they might meet this criteria. So one of the things we're concerned about is, we have a lot of clients that have their operations outside the city of limits, but they do a lot of work inside the city of Tucson. Examples, multi-unit franchisees, you say you have a Jack in the Box franchisee, he may have locations 10 or 12 or more around the city and outside. So they could possibly have two different pay rates. Contractors, you have a contractor that's based in Pima County, but outside the limits, and they do a job inside the city limits, they will have to pay at least the minimum wage. So next, Michael. So if you do not just bump everybody up to the $13.25 or $13 an hour right off the bat, that's a simple solution. Just make sure all of your employees are paid the minimum wage as of April 1 of 2022. But if you decide not to do that, then you're going to have different tracking that you have to maintain inside your office to make sure that anyone who actually works the 5 hours or more in the city limits, that you be sure that you pay them the applicable minimum wage, and you can continue outside the city limits, to pay the $12.15 an hour. So I was talking to a landscaper client a couple of days ago, and they do work all over the county. They said, well, they're already paying $15 an hour to everybody, but they have a few that are at $12.15, the new employees. And they said they will bump everybody to $13 an hour as of April 1, 2022. So, and they don't want to have to comply with figuring out, I have employees in the city, I have employees out. So I think you're just going to see a lot of people just automatically bump it in the county just to make sure they don't have two payroll matters to deal with. Next, Michael, please. So, one of the things that people will do is, okay, you give all of your employees a raise from $12.15 to $13 an hour. Well, that employee that's been there for 2 years already making $13.50 or $14 an hour is going to say, wait a minute, they all got a raise. They're closer in pay to me. I've worked here 2 years already. So what happens is you start raising your pay at every different level of pay grade. So what does that mean to an employer? A lot of additional overhead. And, it comes right out of the bottom line. So, in this day and age right now with inflation, a lot of people think restaurants and these businesses just make a lot of money. Restaurants, if they have a 10% net profit on their sales, they're doing well. Additional labor costs, they have additional commodity costs for food. So this does have a major impact. So we're concerned about that with a lot of types of clients, and it's difficult to continue raising prices. Next, Michael. So I mentioned, you're going to have additional cost, but if an employer loses one of these lawsuits or claims, the employer will be able to deduct the additional back pay, attorney's fees, and costs. If you are assessed liquidated damages, you need to determine if they are deductible. There are some limitations with the IRS. Employees will be taxed on all the back pay and damages that they do receive. Next, please. Okay, so one of the things that an employer has to be worried about is if the city court or another court assesses any civil penalties or fines, which are to be paid to a governmental entity, these are non-deductible by the business. This is per Internal Revenue Service Code Section 162F. They disallow deductions for payment, fines, penalties, and certain other amounts. There are a few minor exclusions. So if you were assessed any of these, you would need to talk to your tax advisor. Next. All right. So the bottom line, if you're not bumping everybody up in the city and the county to the $13 an hour, you're going to have to keep really meticulous records of employee time. And then, like I said before, if you have any penalties, check with your tax advisor. So I think Tim is next.
I am, thank you. So the other thing I want to talk about that's in this act is there's a rebuttable presumption related to retaliation. So, as we're all familiar, Arizona, at least on paper, is an at-will employment state, which means you can hire or fire anybody at any time with or without notice, as long as you don't terminate them for an illegal reason. Basically you have the right to do that, unless you put something in writing with your employee that sets them to work for a specific term or period of time. Unfortunately, one of the things that's in this act that really nobody talked about prior to it getting passed is it creates a presumption of retaliation under certain circumstances. So if somebody files a complaint with the City Department of Labor on this issue, or they assert rights under the act, so they basically make a claim on behalf of a coworker or on their behalf and say, hey, I don't think that we got paid minimum wage correctly. even if it's bogus, the fact that they assert a right under the act and then you fire them within 90 days creates a presumption that you fire them for asserting a right under the act, and there's a presumption of retaliation, which you then have to defend. So what this means for you as an employer is that you have to document whatever performance issues or problems you're having with them to basically overcome that presumption. So in essence, even though you have the right on paper to terminate them for any reason, you really can't if they've asserted a right under the act or filed a complaint in the last 90 days. And this is par for the course because the last ballot initiative back in 2017, the Fair Wages and Healthy Family Act, did the exact same thing. It created a presumption. If somebody takes sick leave within 90 days of termination, you've got to overcome the rebuttable presumption as an employer. So just a huge pitfall that you need to be aware of. And what I tell employers all the time is documents, documents, documents. If somebody is doing a lousy job, document it, because then you can prove later, hey, I fired them because they sucked at their job, not because they asserted a right under some act. Next slide. Go ahead, Richard.
Okay, thanks. Yeah, actually, I think this slide's out of order. Let's look at the next
Yep.
one.
Go ahead to the next one, Michael, and
Yeah.
we'll get back. So pay cards. This is another thing that the that Billy and Amber debated a little bit last time with the Arizona Daily Star. So the act itself, the new Tucson Minimum Wage Act, says that an employer cannot require an employee to receive wages using a pay card that requires the employee to possess a valid Social Security number. Well, one, you have to have a valid Social Security number to work in our state. So it seems a little counterintuitive that you pass an act that doesn't require a Social Security card to get paid. Second, even though Billy tried to argue that, well, look, under the act, all we're saying is you can't require a pay card. Well, you know, the Arizona state law already says that. It says to an employer, you can't require a pay card unless you give the employee an opportunity to withdraw all of their wages without a charge. So we already have this covered under the state law, but this act, this pay card act, is going to create confusion with employers. Well, can I require a valid Social Security number or not? Well, under E-Verify, as well as under the I-9 form, you're supposed to verify that the person has a valid Social Security number to work in our state. So in essence, it's creating a problem between state law and this act that frankly could have been easily avoided if it had been better drafted. And it frankly just wasn't drafted very well because it wasn't vetted appropriately. You know, when a legislature enacts a statute, it goes through a lot of legislative debate to make sure that it's clear and understandable. This didn't do that. Go ahead. Back to the other slide, Michael.
So obviously, as Tim mentioned, this is an issue for an employer if they use pay cards. I don't know what the alternatives are for employees that don't have bank accounts. You know, most employers nowadays do not want to issue paper checks, and that may be what has to happen going forward. So I recommend check with your payroll provider for alternatives to using pay cards if they're deemed illegal. That may be litigated at some point in time. So I think it makes it tough, but hopefully your payroll provider can come up with alternatives, or you're going to have to go back to handing out paper checks for people who don't have can't use the pay cards anymore longer. So next, Tim,
And
anything else?
just piggybacking on that a little bit. So what I've been telling clients, if they are using pay cards, is go ahead and continue still using a pay card. Just put together a clarification that explains that the pay card can be withdrawn without a charge, and that the employee understands that, and they still agree to accept the pay card. And if they raise an argument that, hey, look, you know, under the Tucson Minimum Wage Act, I'm not required, or you can't use a pay card, then I would tell them, put it in writing why you think that, and then you can send it to your lawyer to then respond to, and the lawyer is going to tell you, no, that's not true, and here's why, and then you just push back on the employees so that you don't have to change your pay method with your employees. Go ahead to the next slide, Michael. So the other thing that Richard talked about briefly was large employers. So this is based on an arbitrary window of time. It's looking at the last quarter of the prior year. So if you've got 26 or more employees in that quarter, so basically October, November, December, in that 3-month window, if you've got 26 or more employees at any time during that window, including part-time, full-time, temporary, seasonal workers, then you're defined as a large employer for the rest of the year. So for 3/4 of the year, you're a large employer, even though you may not employ 26 or more employees, but it applies to you for the entire year. The reason why this is relevant for you is another slide we're going to talk about dealing with comp time. So if you're a small employer, the comp law time provisions of the new act don't apply to you, but if you're a large employer, they do. Go ahead, next slide. And the other issue that's relevant related to large employer headcount is it's different than other federal laws. So now you're going to have to, from an HR perspective, count your employees differently depending on which act is applicable. So for instance, under Title VII or the Americans with Disability Act, those two laws are effective against you if you have 15 or more employees for 20 or more weeks in the current or prior calendar year, and those weeks do not have to be consecutive. Now, under this act, you're just looking at 26 or more employees for the last quarter of the year. So again, it's a different methodology for counting, and it's just an administrative burden for you. Would have been a lot simpler if they tied it to something else. Well, first and foremost, I think most of us would argue 26 employees does not make you a large employer. I have more than 26 employees, and I don't think of myself as a large employer. But evidently, under the laws of the Tucson Minimum Wage Act, I am. I think, most of us would agree 50 or 100 or more employees would be a large employer. But unfortunately, under this act, if you got 26 or more in the last quarter, you are qualified. So to the extent that you can keep your employee headcount for that last quarter at 25 or so, then you should be good. The other thing that the act leaves a little unclear is what if you have 26 employees for the first 3 quarters, but then you fire somebody for the last quarter so that you're not a large employer? Does that mean you're not a large employer now? Because the headcount is based on that last quarter. So again, it's a little squirrely, unclear, and the answer to that's going to depend on what the courts ultimately rule. Next slide. If you are a large employer, this is where this compensation rule now kicks in. So prior to the Tucson Minimum Wage Act, you did not have to pay show up time. So hypothetically, if you're a restaurant owner operator and you had people scheduled to work and you have a large patio, which a large lot of restaurants now have because of COVID and needing to spread people out, and you have a patio that's uncovered and it's raining that day, you might have to tell the person, look, I don't need you because we're not going to have as much business because our patio is uncovered. Under this act, if you're a large employer and you're a restaurant owner operator, you've got to pay them 3 hours of show up time, even if there's no work for them to do. Again, something else you've got to track, another thing you've got to pay, which just puts another hardship on the owners of restaurants in particular during a really difficult time for them. Same thing if you're a different business though. Let's say you're a landscape company, or let's actually use a different example. Let's say you're a manufacturer that has a facility in the city limits and the power goes out because somebody hits a stupid transformer on the street, knocks out the power grid, and you have no power, so you can't run your manufacturing equipment to make your widgets. Well, even though it's no fault of yours, you got to pay at least 3 hours to all those employees because they're entitled to show up time under this law. Again, lots of unintended consequences that create hardships on small business owners that are defined as large business owners because they have more than 26 employees. Next slide. Go ahead, Richard.
Yeah, so this obviously creates a major scheduling issue. I think it really applies heavily on restaurants. You mentioned landscapers. You have a rain day, you send them home. A big storm breaks out. So that's really difficult to schedule. And if you're a restaurant and you have your front of house people, the servers and all that, you have to be really careful now about what types of services they perform. So let's say, for example, you have, a server and business really slows down. You'd like to send them home after an hour, hour and a half. Well, you decide, you know what, I'm going to have them go back and clean, do something else. Well, the tip credit rules, the Department of Labor has come out with new rules regarding tipped employees. Next slide, please. And basically what they're saying is that if you, and this is effective December 28th of 2021, is that if you are a tipped employee and you spend more than 20% of your time doing non-tipped work, say you're washing dishes, you're cleaning, you're not doing your tip type work, then you basically then have to pay that person the $13 an hour, as opposed to say the $9 an hour or so that a tipped employee might make. So you have to be really careful about these rules, because you don't want to violate the new Department of Labor rules that take effect in basically starting at the end of the year. So next slide. Yeah, it's Tim.
So the other thing that the act includes is it defines work time really broadly. So many of us may have rounding things in our timekeeping. If we have time clocks under the Fair Labor Standards Act, you're allowed to round as long as it's consistent and there's no bias or prejudice to the employees and to the advantage of the employer. The Tucson Minimum Wage Act now expands the definition of work time, which arguably violates the Fair Labor Standard Act in certain situations. So for instance, under the FLSA, you don't have to pay for de minimis issues and time. So for instance, if somebody has to go through a screening to get into the facility to make sure they don't have any weapons on them, and that takes, all of 1 to 5 minutes, for instance, you typically would not, under the Federal Labor Standard Act, have to pay for that time. But under this new act, you actually have to pay for that time, because it specifically defines work time as including security screening immediately prior to or following the work shift. Or if you tell employees that they need to be here 5 minutes before their shift starts, you now have to pay for that 5 minutes under this act, whereas under the Fair Labor Standards Act, you did not have to do that because of the rounding provisions in that act. So again, it's creating a conflict between state law and federal law. And last time I checked, most employers don't have more money than the federal government. So if a complaint's brought with the U.S. Department of Labor and or the city Department of Labor, you're going to likely just pay the money because it's cheaper for you to pay it than to fight it, even though under the federal law, you're entitled to fight it. Because again, it's a diminishing return for you. Is it worth getting that small win over a few pennies? Next slide. The other thing that this law does is it expands the applicable statute of limitations, which is the deadline for an employee or a related party to bring a claim. This new act expands it to 3 years. So you as an employer could be subject to a claim 3 years after the fact. Whereas the Arizona Department of Labor only investigates within 1 year, and if the amount sought is less than $5,000, and the U.S. Department of Labor only imposes a 2-year statute of limitations unless it's willful. Then it expands, and only then does it expand to 3 years. Whereas this act is saying 3 years across the board, all the time, every time. So it's just a bigger problem for you. Go ahead. The other issue is the double damages that we mentioned in terms of liquidated damages. And that kicks in regardless if the mistake was innocent or not. So if there's a finding of fact on this issue, then the city Department of Labor is going to initiate the double damages, even if it was an innocuous, innocent mistake. They don't care. The act says that they have to charge you double damages. Now, a lot of times you'll be negotiating with the city Department of Labor, and you could say, look, it was an innocent mistake. Here's why it happened. And here's the things that we've done to make sure it doesn't happen again. So you can bargain for or negotiate perhaps a lesser amount. But the city department also has fines and stuff that they're implementing, and that underwrites their budget. So they're going to be less likely to want to cave on the reduction of damages because they're helping justify their existence, which creates a inherent conflict of interest, which is just flat out unfair. Go ahead. So the City Department of Labor, as I mentioned, they've got to investigate their claims within 60 days, which on paper seems fair. But Billy Purd, when he did his debate with Amber on this issue, acknowledged that it would only hire 3 or 4 people. That's just simply impossible for them to investigate all of the claims, especially when the claims don't have to be meritorious. It'd be different if there was a potential stick that the employer could recover attorney's fees and costs against the party that brings a fraudulent and or frivolous false claim. But when there's no penalty or stick that provides that protection, I submit 3 or 4 people are not going to be able to investigate all the claims that are going to get filed within 60 days. Next slide. And again, as I mentioned, they're going to be paid in whole or in part through whatever additional fines that they levy against businesses. And they can, decline or revoke business licenses. They're empowered to inspect payroll records and timekeeping records, which obviously means you've got to be more diligent about that. And a lot of small employers do that in-house because it's cheaper than hire an ADP or somebody else to do it. And if you don't know how to, keep those records, accurately or in a way that you can easily produce them, it creates more administrative burdens for you. And they can level civil penalties up to $100 per employee per day for any violations, which again, that's a huge amount of money. If you've got hypothetically 15 employees and you make a mistake 15 times, over 30 days, do the math. I mean, that's a big number. And again, that money goes directly into their coffers to investigate other employers. So they've got every reason to come down pretty heavy-handed on those issues, especially if they can decline or suspend or revoke your business license. Obviously, you can't operate without a business license. So it's really giving them a lot of power without a lot of oversight and frankly, no direction on how to do their job because the statute is pretty silent on this issue. Go ahead. It also limits payroll deductions pursuant to existing state or federal law and sticks to use the certain payroll methods, which we talked about. Next slide. With that, I'll turn it over to Richard.
Yeah, one of the parts of the act is that, you can't just all of a sudden make everybody an independent contractor. There's some rules in that area. And generally independent contractors are not considered employees, the specialty type work they will do for you. So if you do have independent contractors, this is more of just kind of a warning to make sure you're following the rules. In the past, there was a 20-factor test that business owners would need to follow to determine if someone was an independent contractor or an employee. IRS, Department of Economic Security, they want everyone to be employees because they collect the payroll taxes. And it's much different with independent contractors. Not all of them report their income. Not all employers send out the 1099s at the end of the year reporting what they paid independent contractors, which is an additional burden on employers. So now the IRS has developed a 3-factor test, which is basically behavioral control, financial control, and relationship of the parties. So if you're hiring or maintaining independent contractors, talk to your tax advisor to make sure you're in compliance and that these people are not employees. So next slide, please. So I'll just quickly go through the 3-factor test. So the first is behavioral control. That basically covers facts that show if the business has a right to direct and control the work that's accomplished and how the work is done. So if you're telling the employee, the contractor, how to do it, and you're training them and all that, you may not meet that behavioral control test. The next is financial control. Does the employer have a right to direct or control the financial or business aspects of the job? Next, please. And here are some of the factors. Financial control includes the extent to which the worker has unreimbursed business expenses. Are you paying for those? No, you probably should not be. Does the worker, the independent contractor, have his own facilities or tools used in performing services? Or is the contractor doing it in your office on your equipment? Those are negatives for being an independent contractor. And also, are you doing this type of work as an independent contractor to other companies? Or are you solely doing it for the business you're contracting with? That would be a negative in determining independent contractor status. And then also, are you the one that, as an independent contractor, you realize the profit or incur a loss if you bid the job wrong? Next slide, please. And then relationship with the parties. This includes, do you have a contract with the independent contractor? Do you provide any types of benefits, insurance, pension, vacation? How long does this relationship go on? Is this a service that really the company actually performs for itself? These are all things that if you are providing these benefits, or basically that's the only person's job and it's an integral part of the business, then you probably don't have an independent contractor status. So, IRS looks at this sometimes, unemployment, DES looks at it. So now we have the city of Tucson. So you might actually have independent contractors that say, you know what, I'm really an employee, and then they could file a claim, and then you would have to go through, the city court and the adjudication process. One thing Tim mentioned earlier was household employees. Just as a reminder, if you do have household employees, you are supposed to basically treat them as an employee for IRS purposes, withhold taxes and remit and issue a W-2. And there's special rules on that I'm not going into. So next, please. Back at you, Tim.
Thanks, Richard. And I want to stress the importance of this independent contractor issue, because I foresee this as being a huge area of dispute and litigation because of how broad the worker for hire is defined in this new act. And because, frankly, it's been a huge issue at the U.S. Department of Labor level for months and months and years. So it will continue to be a hot button issue. And then the other thing I wanted to mention, under Arizona state law, ARS 23-1601, it defines what an independent contractor relationship is under state law. Now, again, that's different than the three-part test that Richard just went over with you, which is the IRS standard, which is important from a tax standpoint. But at least under the state law, which is where you're gonna have to defend your claims, right? If you do that independent contractor agreement, that statute sets forth the criteria in which somebody is an independent contractor. So if you've got an agreement or declaration that the person avows to all of that, that's going to make your argument in defending a claim by the city Department of Labor a lot easier to win. So to the extent that you don't have agreements with your independent contractors, you should do that now before this act goes into effect. Now, again, I don't want to put the fear of God in you guys, but there are violation fines that I've talked about a little bit. So just didn't want to end this presentation without just touching on it again, just to be careful on these issues and what this means for you. And some of the retort I get is, well, Tim, if people just pay minimum wage, it's a non-issue. Well, again, the problem isn't just minimum wage. It's all the other crap, frankly, that's in this act that you got to deal with. If it was just minimum wage, all of us will pay minimum wage. We'll do our auditing, self audits, make sure that we're paying people minimum wage. You're still entitled to a tip credit of $3 an hour. So when minimum wage goes to $13 an hour on April 1st of 2022, you're entitled to pay them $10 an hour plus tip credit for the other $3 an hour. You still just got to run the numbers to make sure they're getting paid $3 an hour or more in tips for the work that they perform. So again, the minimum wage part isn't the hard part. It's all the other stuff. But because of the double damages, civil penalties, and the fact that the people that are going to be doing this from the city's perspective are not going to be adequately trained. I know this for a fact because when the Families First Coronavirus Response Act went into effect, I had an employer defending that, and I was educating the investigator on what the law said and how it works. I guarantee we're going to be doing the same thing with the City Department of Labor on these issues. So it's just better to do your self audits and make sure that you're dotting your I's and crossing your T's. If you're doing your payroll in-house, make sure that you're having somebody else take a look at it, that both of you have read the act in its entirety to understand its implications for what it means for you. And then if you're using a third-party payroll company, make sure you're double checking your agreement with them that they're indemnifying you and holding you harmless if they make a mistake and you get whacked for double damages and or fees, to make sure you're protected for their mistake. Next slide. So in essence, the city of Tucson voters, by enacting this ballot initiative, have opened Pandora's box. There's going to be a plethora of new lawsuits and claims that are going to cost taxpayers, employers, untold fees and costs. It's going to be a boondoggle for attorneys, both on the plaintiff bar as well as people like me on the defense bar in defending these stupid things. And it's going to make it ultimately so prospective business owners are going to be discouraged from setting up shop in Tucson, which is really unfortunate when we've been riding this wave of positivity in our community and we've had a number of big wins. But now if you're an outsider looking in, if you got to choose between Tucson and Phoenix, if I'm a new business owner, I'd be looking more at Phoenix because there's a bigger employment pool and you don't got this $13 minimum wage issue that's going to jump to 15 over the next 3.5 years. So with that, obviously, I know Richard and I spoke very, very quickly. If you like the presentation in terms of we gave answers to your questions, my name is Tim Medcoff. If you didn't like what I had to say, my name is Ali Farhang, but we're happy to take any questions that you guys might have.
Yeah, and similar, if you don't like what I said, contact Bruce Beach, who's a retired shareholder. He won't be around. Hey, a couple of things. On your payroll, you need to keep good records and keep them for a while. Obviously, this is a 3-year hold here, but if you receive PPP loans, this is a reminder, you have to maintain those payroll records for 6 years. So do not throw your payroll records away. And most services that we see recommend keeping all your payroll data, history, records for up to 7 years. And like Tim mentioned, document. We in our office, we don't just document what's happened. We meet with the person, discuss it with them, and acknowledge, in writing what we do as part of the documentation so that the employees are fully aware of it. And I'm sure Tim would say the same thing. But Tim, I have a quick question for you.
Yeah.
I believe Flagstaff enacted an act like this. What have you heard about the results and what is happening with that?
So yes, Flagstaff has enacted the same statute. The state of Arizona has sued the city of Flagstaff and Maricopa County, arguing that they have had to pay $1.1 billion in additional labor costs for projects that were already approved in the city limits of the city of Flagstaff. That matter is up on appeal with the Arizona Court of Appeals, and it will definitely, in my opinion, be examined by the Arizona Supreme Court. It is the guinea pig case, and as long as there's not a ruling on that case, the state will file the exact same lawsuit in the city against the city of Tucson. But the damages against the city of Tucson will be substantially more because we're a much bigger city, and the amount of money that's being incurred is over a larger swath of land and area. So the city attorney Rankin looked at this and was speculating, but he thinks it's going to be at least 3 times as much as what the city is going to be sued by the state. And obviously, if ultimately there's a ruling on that sooner as opposed to later, then the state may not bring the suit against the city of Tucson. But if they do, that's going to require the city attorney's office to either defend that or hire an outside attorney to defend it on behalf of the city, which obviously we as taxpayers, if you live in the city limits, are paying directly because it's coming out of the budget. And then if the state wins, then that money has to be paid by the city at some point on that lawsuit. So stay tuned on the end result of that. But obviously, that's a big chunk of change that we as city taxpayers may be on the hook for. Larry, it looks like you had a question.
Yes, thank you, Tim, and Richard, for that very intense presentation, because that's a lot of material. My question relates to the Flagstaff example you just cited, and that is, did Flagstaff also include in their minimum wage act all the conditions and Flagstaff Department of Labor, like the city of Tucson's proposal?
It's a great question, Larry. Honestly, I have not done a deep dive into the city of Flagstaff's act because I don't have many clients up there. And so I haven't had to deal with that issue specifically for them. But I would strongly suspect, without even looking at the act, that it does not have nearly as many pitfalls for employers. My understanding, it was really focused on just getting the minimum wage in that city increased, and it didn't have a lot of the problems that our act has.
Well, I'm sorry, a quick follow-up, Tim and Richard, and that is, do you see a potential, and I don't want to tip a legal strategy here going forward, but do you see a potential for arguing that the conditions that are being placed on employers within the city limits may lead to a ruling by some judge in some court, basically invalidating? Is there any potential for that to occur with severing the conditions from the minimum wage aspect?
Yeah, so yes, I do see that. And if you'll recall, the last time Prop 206 went on, got attacked related to the Fair Wages and Healthy Family Act, one of the arguments was it was unconstitutional because it wasn't one issue. A ballot initiative is supposed to be one initiative, one issue only. And I do think that there'll be a challenge that this one is more than one issue only. I don't think it will win on that provision, but I do. So the longer answer to your question is, I honestly right now don't think it will prevail on an unconstitutionality grounds, but I do think you'll have courts eviscerating some of the provisions in it because of the fact that it's just patently unfair and nonsensical. The large employer is a great example of that because it's taken on average the number of employees that you have on payroll for the last quarter only. As Richard mentioned, most employers boost their number of people on payroll in the last quarter to deal with the holiday crowds. Whereas the rest of the year, you could have hypothetically 26 or 30 or 40 employees on your payroll, and you purposely fire 10 or 15. Now, most employers aren't going to do that, right? I mean, it's just not going to happen. But theoretically, you could, and then you would fall outside the definition of a large employer. And then, even though for most of the year you are, and your employees should get that benefit of the show-up pay, it's nonsensical. And from that perspective, I could see the courts unwinding some of the provisions of it just because of those reasons. Because again, it's not that the writers were stupid. They just didn't think through all the issues effectively enough, which is the difference between a state enacted statute versus a voter initiative ballot initiative.
Tim, real quick, since we have maybe 1 or 2 minutes left, there's a couple questions that came in the chat. One, I think, is a really quick one. Are these criminal penalties or only civil?
Civil.
Okay. Is there any liability for a company for quote unquote renting employees from a staffing service if the staffing service does not comply with the law?
So I'd have to double check, but I believe when I read through the statute is the staffing company is then considered the employer, not you. But I'd have to double check that. And if the staffing company is not compliant, then they're liable. But what I suggest for you as the employer is make sure your lawyer reviews that contract carefully to ensure that one, there's an indemnification hold harmless provision in it to adequately protect you. Two, that the staffing company names you as an additional insured on their insurance policies, and that they have a rider for wage and hour claims that then covers you So then if the company itself doesn't have the wherewithal to defend the claim, that insurance company would then step in or cover you so your belt's fender protected.
You know, for IRS purposes, the staffing companies, leasing companies, PEOs, IRS allows you to look through the ownership and the fact that your employees are under their employment, but they are treated as employees for IRS purposes, like work opportunity credits, FICA tip credits. So I don't know how that plays into what Tim is talking about, but from an IRS standpoint, you get the look through to basically treat the staffed employees at a leasing company as your employees for many tax provisions.
Thank you. And one last question before we depart. Virtual workers, how does that, pay them for 3 hours work if their location is not at the place of business? How do you track for virtual workers?
That's going to be a legal question that a court's going to have to answer, unfortunately, because again, the statute doesn't, as written by the authors, doesn't account for that issue. And then the other question that I thought you were going to ask is, well, are they working in the city limits or are they not working in the city limits? That's the other thing that the employer is going to have to ask them, where is your home? And now they're going to have to do a check to see if that home is within the city limits, because they're working within the city limits. Then you got to make sure you're paying them at least $13 an hour effective April 1st of 2022.
Very good. Well, Tim, Richard, I cannot thank you enough for giving us all this excellent information. We will provide this to the attendees, so I'll email that out. We are also going to post this recording on our website for you and others who want to watch this and obtain this information. Can log in anytime and watch this again. It'll be available on our website. So Tim, Richard, thank you so much. Thank you all for attending, and have a wonderful day and a wonderful weekend.
Thank you.